the intervened case is the one where the government investigates, says there's something here, and we're going to prosecute the case on behalf of the taxpayers, and then it becomes a hand in glove effort with the whistleblower and their attorney and the U.S. attorney.
Hello, and welcome to the Attorney Post. Here's our host, Justin West.
All right. Hello and welcome back to the Attorney Post, where we discuss what's going on in various facets of the law with lawyers at the top of their game in order to help you navigate the ins and outs of the various legal fields and jurisdictions, because, as I always say, if you don't know your rights, you don't have any. I'm very pleased today to be joined with Michael Brady of the eponymous Michael Brady Law, or MBradyLaw, Brady Law, and Brady Associates. How are you doing today, Michael?
I'm doing well. Good afternoon.
Awesome. One thing, actually, the thing I didn't ask you before the show, do you prefer Mike or Michael?
You know,
Or just
Mike
don't call
is
you late for
fine.
dinner. Okay.
Yeah, that's fine. Go ahead.
My listeners don't know this, but Michael is actually my middle name, so I'm a little fond of your name. So, well, again, this is Michael's website. Actually, I don't know if I'm sharing it or not, but we will jump over and take a look at Mike's website. This is Brady Law, MBradyLaw.com. He is based out of Kansas City, and he helps whistleblowers, not just in the Kansas City area, but across the country, if I'm not mistaken. We're going to dig into that today. I'm actually really looking forward to this conversation because this is one of the few areas of law I've really not talked to somebody about in detail. So this should actually be a really good conversation. Before we do that, as always, we are going to jump over to our sponsors. And our first sponsor today is nationalerc.org. You may have noticed that the world went through a pandemic, and many businesses were forced to shut down, reduce their errors, add supply chain interruptions, etc. And this ultimately means everybody suffered from reduced revenue in 2020 and 2021. What you may not know is that Congress recently passed the CARES Act, which allocated about $400 billion in stimulus funds for small businesses that never needs to be paid back. This is not a loan like the PPP or Paycheck Protection Program. This is essentially free money as a tax credit, retroactive tax credit for your business that can be spent in whatever way you think makes the most sense right now. Right now, nationalerc.org is helping small businesses get the maximum amount of money that they can, and you can calculate and see how much you can get simply by visiting nationalerc.org and filling out this short little survey. The average small business that we work with gets over $200,000 to invest in their business that never needs to be paid back. The calculator is free, and again, there's never a fee unless we secure funding for you, unless they secure funding for you. That's nationalerc.org, link in the show notes below. Our second sponsor is Groove Pages. If you love spending $5,000 to $10,000 on new websites, and you love paying $200 or $300 a month to have hosting and security and all of that on a platform that allows you to sell products to your potential customers and clients, then by all means keep doing whatever it is that you're doing. But if you are like me, you hate that. And that's why I personally recommend Groove Pages, the all-new, all-in-one funnel website page builder from internet marketing legend Mike Filsaime. Visit theattorneypost.com/groove to sign up for free and build a complete site at no cost. Really, truly, no cost. There's no cost, and you can build, actually, I believe, up to 3 fully functional websites. It's basically a Swiss Army knife of a website. It replaces all of the major software platforms you would ever want to be using, from your website host to a service like ClickFunnels to the shopping cart platforms to webinar platforms and everything else. It really is a Swiss Army knife. And again, you can get started completely for free. Just visit theattorneypost.com/groove. No credit card needed to get started. All righty. So we are back here. And again, MBradyLaw.com, link in the description below, should be the very first thing in the description. In fact, is Mike's law firm. You can also give him a call at 913-696-0925. So Michael is the eponymous lawyer behind MBradyLaw. He got his start with actually degrees in business and finance before back in 75 and 81. And then it was about a decade and a half later, I believe, that he got his JD and LLMs from UMKC and began practicing law. For almost 20 years, Brady Associates team has served as the whistleblower attorneys, representing workers in their fight to assert their rights to fair treatment and just compensation in the workplace. In that time, his firm has litigated Fair Labor Standard Act and employee discrimination cases on behalf of employees that resulted in over $25 million returned in wages and damages. So my first question, as always, Michael, is, having said all that, what did I miss?
I think the overview is pretty complete. I opened my firm in 2000, and
Okay.
It started out focused on employment law, and an offshoot of that was wage and hour or wage theft cases. And I still do take a good look at a number of those. Frankly, myself and number of other plaintiffs' lawyers have worked diligently, and I think there's substantially less wage theft, at least on a large organized scale, than there used to be. So about 15 years ago, I decided to step off, not just quit doing employment law and so on, but to step off and look at other facets of employment law, and particularly got interested in the area of the false claims arena. And let me just kind of highlight, some people might know it as what's called the Lincoln Law. It also most of the abbreviation is FCA. It's False Claims Act. It's a law that was put on the books at or around the time of the Civil War. And the reason it's called the Lincoln Law is Abraham Lincoln felt like there was so much waste, fraud, and abuse surrounding the supplies being supplied to the Union Army. I've heard two origins of that story. One is that they were ordering 25-pound casks of black pepper, so think like peppercorn, and they were supposed to be 25 pounds net, and you could weigh the casks, and they wouldn't even weigh 25 pounds, including the cask, and you can imagine how heavy a wooden barrel was. That was one example. The other iteration of the story I've heard, and I'm not sure which is true, but the powder that they were talking about was like black powder for firearms and cannons and so on. But anyway, the point of the scenario is it's a law that was on the books for many, many years. And then probably in the late 60s, early 70s, with the growth of Medicare and the various other things that are out there, what happened was that it was expanded, and they started to look at anything that related to federal dollars that were being spent. And as Abraham Lincoln reportedly said, it sometimes takes a crook to catch a crook. By that, what he meant was you need inside information to be able to try to tease out and identify a fraud scheme. I mean, if it's well papered and nobody's telling anybody about it, the inspector general can come and look to their blue in the face and everything's going to match up. But if it's a systematic fraud, and by the way, these are not aimed at good faith errors that businesses make, because we're all human, that happens, but they're really aimed at addressing the intentional frauds. Look, for example, I'll use a quick example. In the area of Medicare and Medicaid, which is very common, there's where they bill for procedures that weren't performed. They upcode, meaning they charge for procedures, lesser procedures, and charge them at a higher rate, and those sorts of things. But the genesis of all of this is trying to protect your money and my money as taxpayers from the waste, fraud, and abuse that is out there. Probably more than you wanted to know, but it certainly gets us into the field.
No, it does. And those are, again, I actually was going to ask some of those questions. I didn't really fully understand, what went into a number of the areas that you actually focus on, including the false claims and the wage theft and everything else. And I'm sure we'll dig into that more as well. But I like the historical note behind it, because I'm a historian by trade. My degrees were philosophy and history, which I always joke, qualified me to ask the deep questions in life, like paper or plastic, or you want fries with that, which is why I wound up getting into marketing and podcasting. But that's
exactly.
That's life and the way it works. So, Michael, give me if I was stuck with you for 30 seconds or a minute in an elevator, and I just asked you, what do you do? What would be your elevator pitch for what you do, who your ideal clients are, and why they choose to work with you?
The elevator pitch is that if the public fisc, meaning the taxpayers' money, federal, and there are a number of states that have similar laws, but if the taxpayers' money is being systematically soaked up by waste, fraud, and abuse, but in particular fraud, I help the whistleblowers bring those matters forward. Now, it's not a completely benevolent arrangement in terms of the Lincoln Law, or the False Claims Act generally has a scheme that says between 15 and 30% of what the government recovers is payable as a bounty to the whistleblower. And most of the other state state laws mirror that. And it's been so successful over the years in the concept. I don't remember the DOJ's numbers, but it's billions and billions of dollars has been recovered. And also large payouts have been accomplished, for whistleblowers. But, it's the age old story. There's got to be something in it for most people to come forward. Yeah, it's true. I have worked with some people that the money didn't seem to be a motivation. That's probably probably among my better client characteristics. But there can be significant recoveries. And the last thing I'll say is when I talk about whistleblower, don't think of it just as the False Claims Act, because the concept has been so successful over the years from the 60s on, that there were a myriad of the Securities and Exchange Commission started their own parallel system. There's an IRS whistleblower program as well, and several others. And most of them are mirrored after this structure where the whistleblower brings the case on behalf of the taxpayers, and that case is pursued, and then the recovery, the whistleblower, the person that is called the relator, it's not realtor, it's relator, that brings it forward. They're in for basically this portion or the bounty. So there's a number of parallel there. I think now there's 15 or 16 different scenarios like this where someone brings it forward and brings something forward, and there's a bounty provision, which is frankly how I put bread on the table as well, is part and parcel of that.
Gotcha. When you work with somebody and they're a whistleblower, how does your fee structure work? Do you work like an injury attorney? I know you do injury law, and that you take a percentage of the winnings, the judgment, the settlement, the bounty, I guess in this case.
And I want to explain. This is a good point to explain this. The bounty is a sliding scale, if you will, depending on how much involvement and how valuable the information the whistleblower had. But that 15 to 30%. Oh, I know something else I was going to mention too. I'm going to talk mostly about the federal false claims statute because it's kind of the grandfather of everything. General rule, most of these statutes, certainly the FCA, it's a treble damages statute. A lot of people are familiar with that in antitrust law, where the Sherman Act, for example, said, okay, we're going to take the damages and we're going to multiply them by 3 and move on from there. The False Claims Act has that same provision. So whatever the taxpayer was defrauded of, if indeed you litigated it and proved it all the way through, the damages would be tripled. Also, there are a number of in the FCA arena. There's a specific penalty for like administrative penalty, and I've forgotten now. It can be in excess of $20,000 per submission. Let me give you a concrete example to put this in form. And as I tell people, kind of jokingly, whistleblowers, I tell them these damages can frequently become, they jokingly, but they approach the national debt in this regard. So you have a Medicare case that goes through, and the damages are millions of dollars. Those get trebled, but on top of that, the penalties portion of it, every individual submission can be deemed to be become another part of the damage calculus. So if every time they submit a false bill to Medicare or Medicaid, then they could be also the administrative damages could be applied as well. And quickly, this thing becomes what the government typically terms as an ability to pay case, meaning they will impose a settlement or a penalty on the bad actor basically looking at what their assets are, because and they'd be guided by the typical bankruptcy scenario and those things. But that is is part and parcel of this. So I think I don't know if that answered your question.
I think more or less it sounds like it's complicated. So, but if somebody has an issue,
I'm sorry. Excuse me. I'm sorry. No, in terms of our fee structure, yes, it's a contingent fee arrangement, meaning that the whistleblower or the relator is not going to pay me for an hourly rate or anything like that. If we get a recovery, we get paid out of that. Now, again, there's some mathematics involved in it, and I won't spend a lot of time on it here, but it's not. It's the first order of business is you get the government to intervene in the case, and I'll talk more about that later. But you get the government to intervene in the case, and the vast majority of cases the government does pick up and intervene. Then the government then there's going to be a settlement. And frankly, the government usually doesn't settle these cases for all the possible damages. Frankly, I'm not sure who could typically pay them. I mean, the statute is really pretty draconian, as written, if you will. But that being said, so our fee structure is basically a portion of what the recovery is, and obviously we have to work hand in glove with the government. And the one thing I will, and I explain this at nauseum to clients, it's really not our case. It's actually the government's. Excuse me. These things are also sometimes called qui tam or qui tam cases. It's a Latin phrase for he who brings suit on behalf of the government, and it's really is ultimately the government's case, and they have a large say in. For example, we can't settle one of these without the government approving it.
Gotcha. Okay, that makes no sense. So, moral of the story, though, if someone is out there and they're a whistleblower and they don't know what to do, step one would be contacting an attorney, and don't worry about the cost, because there's not going to be a cost to get started, to get the process going, to get consultation, to figure out what your rights are, to figure out what needs to happen, and then you'll help them figure out, in the end, how to resolve the issue. And there's not a fee unless you solve the issue, and then that comes out of what the government would pay as a bounty, more or less.
We're less successful. Okay. I would like to interject at this point when you say the first order of business.
Okay.
There's a couple of nuances or things that are very unique about this area of practice. And this applies certainly to the Federal False Claims Act, but it also applies to other whistleblower situations as well. But in the Federal False Claims Act arena, there's a couple of things at play that are very important. Number one, and this is to the specific question of action steps that a client should take. Number one, the Federal False Claims Act, the case is brought, we actually file a lawsuit, but the lawsuit is filed under seal. So think like a criminal indictment. It's sealed until the arrest or the matter goes forward, and things can be sealed for a long, long time while the government investigates and so on and so forth. So the case is filed under seal, which also helps to keep, for at least at the front end part of this whole process, the identity of the relator or whistleblower is not public. But the other thing is this bounty that we've been talking about. There's what's called a first to file bar, and what that means in plain English is whoever gets to the courthouse with this case first gets the entire bounty. So you, as you can imagine, the scenario comes up. I'll use the example, and I've used it a number of times. So a couple of pharmacists are talking one day at work, and they're looking at how this billing process is happening and so on. And they're saying, God, this seems like a scheme to defraud. And they both basically go to their corners and say, okay, we got to do something about this. And they don't take action together. They individually seek their own legal counsel. One person got to the courthouse with the claim that was very valuable and got the entire bounty, and the second person got zero. So first and foremost, if you have a claim that you think might be live for something this sort of thing, is number one, don't talk to anybody within the organization or anyone else who could have this sort of claim or have the knowledge to get it filed. And so you want to do that, and you need to seek competent counsel early on, because one of the other things that happens is, for example, if you start talking to people, or even if you go to your average, and I don't mean the average good or bad, but your typical lawyer who's not familiar with this area, what happens is they said, okay, I want to talk to witnesses, and I want to find out information, and I want to get the best information to put together the best case I can to make it easy for the government. The problem is they may very well have just tipped off 15 people that these claims are out there, and you can easily lose control of the entire process.
It makes sense. I could see that. So, and it's the tagline of my own show here. If you don't know your rights, you don't have any, and you don't know what you don't know. So, step one, as always, seek competent legal advice, talk to an attorney, and obviously, especially if it's a whistleblower issue, it sounds like clearly already you can tell Michael has a good head on his shoulders and a lot of experience in this arena. Well, Michael, I want to take a step back from talking about this for just a minute and just get a little bit more general first, because I had a couple of just curiosities. Again, I noticed that you had your degree, an MBA, I think in finance and a few other things. So clearly, law wasn't your initial goal in life, but somehow you got into law. So can I ask you a little bit about your journey into law? Was law kind of your long-term goal you knew you were going to get into? Or is it something you kind of stumbled into? Did you always know you wanted to be an attorney, or how did you wind up doing the type of law that you do?
Having been, I grew up in a family business, and candidly, there's if you're in business in modern times, there's a certain amount of litigation and so on. It sure seemed like it anyway. So over the years, and then that business closed and moved on, and I was always fascinated by the law. As I can't say that I have that I'm this, civil rights and some of that, those arenas. I think I'm a little more practical. And yes, I got into the law because it was both a decent business opportunity, but it also allowed me the opportunity to, I think, make a difference. So that has come through in terms of the wage theft arena, helping people get paid real money. It's not just like coupon settlements and that sort of thing. And then in this whistleblower arena, it's encouraging to be able to try to recover money for the taxpayers, while at the same time, many of the relators, it's a long journey. These things take a long time. I sometimes wonder why they take as long as they do, because you're dealing with the government bureaucracy and so on. But that being said, I think my early business development and being out there, it seemed like the being the lawyer and that information or that profession, I think it suits my personality. It took me a while to find it, though. You're right.
Gotcha. Okay, that makes a lot of sense. Kind of on a related note to what I was saying earlier. So one of my sponsors does the COVID relief stuff, nationalerc.org. Link in the description below. Obviously, we just got through with this whole pandemic. And I've talked to a lot of different attorneys, and a lot of them have had very unique experiences with how the pandemic affected them, their practice law, et cetera. So I was curious if the pandemic affected you at all, and also if it brought up any kind of unique cases, or if you're seeing any kind of unique whistleblower, I don't want to say opportunities, but like, are there realms where you think whistleblowers are going to come forward on something involving, just the way the day-to-day pandemic stuff, the way it was handled, or did it open up new areas or avenues, or what's been your experience with the pandemic as an attorney?
Good questions. Okay, so by the way, I think it's ERC is your sponsor. I noted that down because, like every other business owner running a payroll, the pandemic, yes, the business slowed down. There's no two ways about it. So I have some interest on my own behalf about that. That being said,
NationalERC.org.
yeah. So anyway, but the yes, the pandemic, it seemed to have an effect. Frankly, it had a twofold effect. I think there was less business. I mean, there was less interaction, less business. For example, like just in the medical field, you had people doing Zoom calls and various other things, and not direct. And the medical billing and all. I just say that it did seem to depress everything. A sidelight in the personal injury space, like with regard to car wrecks and so on, it was really interesting. I talked to a couple of folks I know that really, I mean, they specialize and do a lot of automobile stuff, and they said there weren't any accidents. I mean, there was no business. Yeah. But anyway, but back to your second, or the second part of your question is really a very good one. What's out there? Okay, so the government pushed out literally billions, if not trillions of dollars into the PPP program and so on and so forth. And there were a lot of legitimate businesses that had payroll and they took the money and so on and so forth, frankly, myself included. But that being said, there were an awful lot of hucksters that got in and, here's an imaginary company with imaginary payroll and so on and so on and so forth. And the cleanup of that process, as frankly is in its infancy. And by the way, if I haven't said anything to anybody about this, the Federal False Claims Act generally has a 6-year statute of limitations, so you can go back a ways. But that being said, it seemed like the PPP loan fraud was a prime target. Now, one of the things that has showed up, and I've talked to some of my brethren that do some of this sort of business, many of the PPP loans, even if they were completely bogus and fraudulent, they're frequently not that large. Typically, on a whistleblower case that has real legs, you're getting a slice of the pie. And the other thing is, and the government they may deny it, but I think it's pretty obvious that they look at cases that myself and others bring. And if the damages aren't the recovery isn't likely to cover the cost for them to try to do the investigation, that's a factor in whether they're going to take the case seriously. Now, if there's patient harm involved or other sorts of things, those are mitigating factors, and they frequently will, that'll move it up the list. But the PPP loan fraud is out there, and anything related to the hallmark of all of this is it all starts with, is there government money? Is there public fisc? Is taxpayer money involved, state or federal? And then you go on and look from there. The one thing about the PPP loans is, I say, frankly, the ones where they're completely fraudulent and they're that bad, when the U.S. Attorney's Office gets wind of those, they're prosecuting them criminally. The federal false claims statute, it does have a criminal component, but it also is primarily a civil action or a civil statute, and the government's trying to seek money. If the case goes and there's a criminal scenario, it's a criminal referral, and it actually is prosecuted, what frequently happens is the government, between restitution and various other things, there's not a pot of money for the civil side to get any kind of recovery out of, and so it makes the case difficult to prosecute. So with PPP loans, the complete wholesale frauds are frequently being prosecuted as crimes, and then the other cases, there's some issue as to whether they're sizable enough to make the math work. But there was likely a great deal of PPP fraud. At least that's what the U.S. attorneys that I've worked with they're keeping busy trying to clean this up.
I had a number of people suggest that you need to hire your wife and pay her, $70,000 a year right now, and then make these sorts of claims. Would that fall under that sort of? Would that be considered fraud? And I don't know if your expertise is just in what is and isn't fraud in these particular cases. I don't know if that's necessarily what you yourself would handle, but I'm just kind of curious, since we're talking about this topic, if you have any knowledge on that, because I always felt like that felt dishonest. I didn't do it, but I thought it was an interesting concept. I was like, wait, you're telling me I can just hire my wife, pay her a $70K salary a year, and the government will take care of that and forgive it? Like, that felt a little weird. Was that abuse?
In a vacuum, what you're describing could very easily be fraud. Yes. Now it depends, and we're a small law firm, and my wife has kept the books and records, and I've paid her for a number of years. I remember when we were actually applying for the PPP loans ourselves, that we had to send them historical records of payroll, so it was legitimate employees. But what I'm hearing you say is if you, for example, people like would try to manufacture employees after the fact, because I remember we had to furnish them our payroll records and various other things, and so on and so forth. And I'll be frank about it. At the time that I was seeing this, I was thinking to myself, there seemed to be fairly good safeguards involved. But obviously, we were doing it through our banking institution, which we've had a relationship for years and years, and I think it made the process easy. I don't know if there were. I'm not sure how all the money was rolled out.
Gotcha. Okay. I was just curious if you had any knowledge or any weigh in on that. So, but that's all right. That kind of answered my question. So let me ask you this. We'll ask a little more of an interesting question first, and then we'll kind of get back into some of the ins and outs of whistleblower law. You've obviously been practicing for almost 20 years now, give or take. Actually, a little over. If it was 20, you said 2021?
I opened in 2000. So yeah, this is the 23rd year. Yes.
23rd year. Congratulations on that.
Thank you.
Pretty big. Undoubtedly, in your practice of law, you've had some successes and you've had some failures. So I always like to ask my guests these two questions. And the first one, obviously, is tell our listeners about a time in your practice of law that you had a setback, you had a failure, something that struck you as a failure. Maybe it was a case that didn't go your way, a judgment didn't go your way, you forgot to fill out a form, or whatever happens to be. But obviously, it's only a real failure if you didn't learn from it. And so tell us about a time in your practice of law where you had what you consider to be a failure, and what you learned from that, and how you carry that forward to make sure you're taking the best care of your clients, et cetera.
The example I will use, and it's a matter that was, it's been, when I talk to you about these cases are filed under seal. So this is one that's in the public domain and so on. And I won't get into any of the specific details of it, but it was medical, not medical malpractice, but it was medical services. And it was, we thought that they were overcharging the government significantly. And the other thing I will say is, on some of these sorts of cases, if they're big enough, I will get with other practitioners in the false claims space, and we'll joint venture on a case and so on and so forth. So this was that situation. And we thought we had very good evidence and very good liability and so on and so forth. And let me back up one step. So the other thing is, the government has it's the government's case. If the government says, we're not going to pursue the case, you, Mr. Whistleblower, and your attorney have the right to pursue it yourselves. So when I made the reference to if it was an intervened or non-intervened case, the intervened case is the one where the government investigates, says there's something here, and we're going to prosecute the case on behalf of the taxpayers, and then it becomes a hand in glove effort with the whistleblower and their attorney in the U.S. Attorney's Office. But they also can say, we're not going to intervene in this case, and we're going to now, under the false claims statute, a non-intervened case can be litigated, and then it's just federal general litigation, as you would expect. So this was a non-intervened case, and I formed a joint venture. Long story short, just we were on the eve of trial, and what happened to us in the whole scenario was the judge there were all the motions pending with regard to the defendants basically saying we don't think there's anything here, and as a matter of law we think the court should dismiss it, and the judge dismissed it. Frankly, within 2 weeks of the trial date, we had already subpoenaed the witnesses, we'd produced everything else. So what I learned from that, and we had spent substantial effort and substantial preparation and so on and so forth. And so what I took from that was, particularly in the false claims arena, that trying to litigate non-intervened cases is very, very difficult. And just like in any litigation, you can think you've got the greatest case in the world, but it's a system, and there's just so many unknowns and so on and so forth. I try very hard to prepare clients for these sorts of outcomes, but the bottom line is that when, like any litigation, there's no guarantees, and you try to do the best you can. I think it also, while I'm not saying that I would recommend ever trying to prosecute a non-intervened case, but if the government has spent the time and the effort to investigate, and they make the decision not to intervene, and they usually tell us a good deal about why they have done that, then frequently that forms a significant opinion about whether it's prudent to try to carry the thing forward. And so I think of it as a failure in terms of the case was unsuccessful. The lesson I took from it was that there's no guarantees, and you have to really be you have to really fly spec and look at every, particularly a non-intervened case, because the risks of litigation are magnified.
Gotcha. Okay. I mean, that makes sense. And it has to be a little bit of a heartbreaking scenario to be in with all that time and everything else invested in that case. But I guess that is sometimes just the way that it goes. Well, the
Yes.
flip side of that, of course, is I'm sure you've had some great successes and some great wins. And I'm sure there's one or two that, they're the feather in your cap, right? They're if you had to go to example of, this is just everything went great, or this is a case I'm really proud of, or this really made a difference in people's lives. What would one or two of your biggest successes or moments you're most proud of look like?
For example, let me talk about one FCA matter, the false claims matter, and then I'll also talk about a wage theft scenario, or those sorts of things. Now, the one of the early false claims cases that we worked on, it was so egregious that that the medical equipment supplier was literally billing the government for equipment that wasn't even provided. And frankly, that one it ended up being, they made a criminal referral and they actually prosecuted them criminally. And that, as well, they did recover some money on the civil side as well. And we got a very favorable result for our relator. So that I view as a great success in the false claims arena. Just the outright fraud. With regard to the wage and hour arena, I've had a number of cases, and like so many of these that have been settled, all I can say is the matter was resolved. But I've had a couple of multi-million-dollar payouts for back wages and so on and so forth that went to a number of people. I think I made a reference early on to coupon settlements.
Yeah.
I think that some of the plaintiffs' lawyers in particular have gotten plaintiffs' attorney class action lawyers when you would bring a case on some fairly arcane technical violation, and then and I can understand it from both sides, but the lawyers might litigate it and so on and so forth, but the damages are so small. Think of a consumer class action, and then what you would see happen is someone would say, or the settlement would say, we're not going to admit liability, and we don't want to pay a whole bunch of money in real dollars, but what we'll do is we'll give our former customers a discount in the form of a coupon that they can use for goods or services going forward. So it becomes kind of a win-win. And in some of those cases, the plaintiff's lawyers would have worked a ton of time on the case and so on and so forth. And they were contingencies, so they took the risk and so on. And so the plaintiff's lawyers would get their significant fee payout. But if you're John Doe and you get a coupon for $12 for your battery or some other product or something, but in the disclosure of the settlement agreement, and the court has to approve most of these, or the court has to approve these sorts of settlements, the plaintiff's lawyers might be listed as having recovered multi-million dollars, and people go, how could they possibly justify that? Well, they've affected change for a number of people, and also, frankly, the defense lawyers, they got their hourly rate for working all this stuff up, and the plaintiff's lawyers are oftentimes working on a piece of the pie. And as my earlier example, not every case is successful. Now, the defense lawyers in that case that I had talked about previously, I'm sure they did quite well, but we on our side sure as heck didn't. A contingent law practice, there is a modicum of that the winners pay for some of the losers' efforts. It's just a fact.
I've not heard that. That's an interesting concept. So if you're a plaintiff lawyer and you win, your winnings still cover the cost of the losing defense?
Well, in this regard, I've got overhead and I've got expenses and various other things, and I might be working on several other cases, and so I've got to pay the expenses on that. I'm talking about from a business overhead prospect, and if you're looking on it on a broader scale, but the problem with the contingent law practice is that if you get a defense verdict, for example, you take something to trial, then there is no recovery. And obviously with the contingency, the nice thing about a contingent, and I'm talking about in generalities, but the contingent contract or contingent attorney's fee contract basically is it allows people to have access to the courthouse who might not otherwise have access. And so, the plaintiff's lawyers, well, a lot of this we're funding out of our pocket.
Mm-hmm. Okay. No, that makes sense. And yeah, well, that does make sense. So let me ask you this. I'm sure people have a lot of misconceptions about what it is that you do, what it is you can do, what it is you can't do, etc. What are some of the biggest misconceptions people bring into your office about, what's going to happen in a particular scenario?
Let's talk about the whistleblower arena specifically.
Okay.
So somebody comes in, and first of all, let's say it's a Medicare or Medicaid patient or whatever, and they think that this doctor overbilled or this practice overbilled for something. There are a number of good faith errors made. So the billing process is not perfect like anybody else. And you look at that, and you look at that scenario, and the um, and so it may not be a fraud. You have to understand that this area of practice and these statutes are aimed at rooting out fraud. They're not based on penalizing someone for making a mistake. So I have people frequently come in and you frankly, Justin, you made the comment earlier, you said something about people don't know what they don't know. Well, that's very true. And that's why I try to talk to everybody that contacts my firm, because the best example is, let's say if somebody works in a medical practice or a hospital building, something such as that, and they might call me about an employment law matter, which I may or may not be able to help them with or send them to somebody who can. But I oftentimes like to ask them about these sorts of things because they'll have noticed irregularities. And I've more than once I've had someone say, God, I never thought about that. I thought it was strange, but go on from there. So people don't always know what they don't know. But so the FCA, the false claims is a fraud statute, or any of these things are aimed at systematic frauds. Good faith errors that won't cover it. The other thing, and I counsel my clients frequently, I think there is a lot of garden variety fraud out there that people that is experienced, and I don't know if it's who can prove it or can't prove it, but the bottom line is somebody, even if it is an actual fraud, if the marginal cost for the government to investigate and recover the money is too small, or is I'm sorry, if the marginal cost of the government's investigation is $500,000 and we're going to try to recover 10,000 or 20, it's really not worth pursuing on anyone's part, not because it isn't something to be addressed, but unless there's a patient harm issue or something like that, the government, they're the administrative, the DOJ and the various people that are dealing with this, they're supposed to be trying to guard the public's funds, and to needlessly expend funds on an investigation that isn't going to make any kind of reasonable recovery, that would be irresponsible as well.
It sounds like the setup for some sort of a book or a movie where people figure out the perfect crime is to steal $10,000 here and $10,000 there from the government, and always doing it in ways that are never big enough to be worth going after. If someone were to do that, is there some other recourse that you could take, or is it just the type of thing that, well, we know that waste is going to happen and we just kind of accept it? Like, I don't want to be dour on the government. I'm a libertarian at heart.
Sure.
I'm a government that governs best, governs least sort of a guy. And
right.
It just sounds like this sets things up in a way where it's rife for fraud without a real system, unless it's a huge pot of money, which, maybe people just get greedy, they keep doing it, and eventually it becomes a huge pot of money. But it just strikes me as, if nothing else, you could write an interesting Tom Clancy novel or something, or a John Grisham novel about, government fraud.
The point you are making about the small-time fraudsters, if they don't get big enough to get on the radar, can probably get away with a lot. I don't mean to give anybody a primer or encourage anyone to do that, because, again, it is still a crime. But, at its core, plus the civil damages and so on and so forth. But I and my fellow practitioners in the false claims arena, we have more than once lamented that the small-time fraudster, if they don't get big enough and if they don't get greedy, they can do a lot of this. I mean, there's just no two ways about it. Now, at the other side of the coin is death by a 1,000 paper cuts is still death. So I don't have a good answer for your question, other than it is a conundrum noted of myself among, when we go, I go to some of the seminars and so on and so forth. And I'll throw this out there, and I would hope that people that see this podcast would call me first, but the lawyers that are practice in this area are primarily members of an organization of taxpayers against fraud, or TAF, taxpayers against fraud. And it's really kind of interesting. As much as one would say, and I'm not trying to get into politics here, but for many years, and I think most people would agree, that the Republican Party is particularly corporate friendly. But frankly, the greatest friend of the false claims arena, excuse me, I need to not answer this. So the greatest friend to this arena has been Senator Chuck Grassley of Iowa, and he has been for years. And he bases it on, I want to, stamp out the waste, fraud, and abuse. But I will tell you that the corporate interests have more than once have gone after the false claims statute to try to cut it off in various ways, to try to eliminate it, because they really don't like it. It's a way that the government and also that they can, their feet can be held to the fire.
Gotcha. That makes a lot of sense. A couple of quick questions about whistleblower law, and I do want to be respectful of your time. I appreciate you giving us as much time given.
Take as time as much as you want.
All right.
I can do this in an elevator speech, or I can talk all day about it. Go ahead.
So one of my questions is, obviously people who are whistleblowers have concerns about what happens if people find out who I am. Is there going to be retribution? So what concerns are legitimate? What concerns are unfounded when it comes to being a whistleblower? And what steps should the whistleblower take? What steps do you take? What steps are taken at a governmental level to protect whistleblowers? And how successful are those steps?
Okay. So in the Federal False Claims Act arena, we shorthand it and call it an H, like Henry, an H claim. And it's a portion of the statute that it allows for recovery of retaliatory damages. So those are above and beyond the actual damages, or the treble damage, or all that other stuff. So that's a claim for the actual whistleblower. So statutorily, I would tell you that retaliation for bringing a whistleblower claim is against the law. That being said, now, at various stages in this process, and when I tell people and I want to be clear about this, if I tell someone, okay, the lawsuit is filed and it's under seal, and I need to spin this off just a little bit, but let's talk about the FCA. The case is filed, it's under seal. At some point, the case is concluded. The government intervened and settled it, and the original complaint is unsealed, and the settlement is generally unsealed, or the government, you've seen press releases about the Department of Justice recovered X, whatever. That at that point, that original complaint becomes unsealed, and the identity of the whistleblower at that point will become known. I've tried to for privacy reasons and all, to argue with courts to not do that, but they say it's a lawsuit in the public domain, and therefore it can be there's no way to keep it private, if you will. Right. Now, I will tell you, I've dealt with a number of whistleblowers, and some of them, or I say all of them, go on to other jobs and other careers and so on and so forth. But I will be very candid about it. I think particularly in the pharmaceutical industry, it seems like if someone is a whistleblower in a large pharmaceutical case, I very much doubt they're going to work in the pharmaceutical industry, ever again. And I'm just being, that's anecdotal evidence on my part, but I've talked to other practitioners. So, there are some industries where, there's not going to, I think that's probably the biggest, is the most likely scenario. Other industries, I think it runs the gamut. The other thing I would tell you is, if the case is non-intervened, and we're not, and we or the lawyers I'm going to help with, or we're not going to pursue it, we very quietly dismiss it, and it's a one-line entry in the.
Might have lost you.
Yeah.
Oh, there you are. I think you froze up. You said it was
Oh,
a
I'm
one-line
sorry.
entry, and then it froze up. Can you just repeat the very last sentence that you said?
I'm back. I'm sorry. Okay. I thought, God, I paid for good internet too. Anyway, no, but so what I was going to say was, if in the event that it's a non-intervened case and it's not going to be pursued, it's a one-line dismissal, if you will. Yes, the complaint's unsealed. We put as little identifying information in the complaint about the relator as we can for that reason. And so unless somebody was actually looking for it, they're unlikely to find it.
Gotcha. Okay. If a whistleblower feels like they've been discovered or outed and they feel like they're being treated unfairly, do they come and contact you about that?
If the case is the short answer is yes. And by the way, you can bring a civil case, even if there's not a legitimate false claims case as part of it. You can bring an H claim, even if you don't file a false claims case about it. Can I throw in one other thing? And I've talked a lot about this, but when you say, what did you forget? Of course, you always remember something. But the one thing I wanted to talk about was, particularly when people talk about a false claims, you think like it's a fraud or whatever. There is also a thing called a reverse false claim. And I probably should have said this sooner. A reverse false claim is one where there's not a fraud when the contractor or whoever collects the money from the government, but they audit themselves and they figure out we've been overpaid by the government for this good or service. And then they say, well, the government doesn't know and they don't care and they're not asking for the money back, so we're going to just keep it. That is a false claim as well. It's called a reverse false claim. And frankly, in that scenario, you have to prove less. There's less requirement to prove what they call scienter, meaning that they had a bad intention. That was an intentional fraud, because once they do the audit of themselves and they out themselves and they say, well, we're just going to keep the money, it's a game, set, match.
Yeah, no, that makes sense. And I guess it's kind of, it makes me a little afraid to ever deal with the government, ever. Accidentally get overpaid, go to jail. Accidentally underpay your taxes, go to jail.
Well, but the problem is the governments, they're a huge part of the economy as well. So, I understand what you're saying. I get it. And don't get me wrong. I talk to people all the time and they think it's a fraud. And I'm going, if it's a good faith error, we don't have anything. And I run a business like anybody else. I mean, everybody makes accounting mistakes and various other things. I think and I'm overarching comment here. I think what we're highlighting and talking about is the decay of ethics in business and society and so on. I mean, you really did probably learn everything you needed in kindergarten about how to play nice with other people.
Yeah. I think it was Sigmund Freud, actually. I'm not a huge Freud fan, but every so often he says something that's really insightful. I think he said, courtesy is the glue of civilization or something like that. And I think we live in a very discourteous and society. And as we've lost our courteousness, we've kind of lost a desire for honesty and truthfulness and uprightness and everything else. So that's just a personal offhand observation about the world around me. Obviously, everyone can be an individual.
I will have to say, ditto. I agree. I think that's a real problem, and waxing poetic here, but I'm not sure if social media is a good thing or a bad thing.
I know that the wealthiest people, the social media makers, Steve Jobs before he passed, Mark Zuckerberg, all the people who lead these industries generally don't let their kids have access to these tools. And of course, in a lot of other places, even TikTok. And I've talked to a lot of attorneys that do TikTok marketing and whatnot, which is interesting. But apparently, and again, I'm not going to get overly political here, but apparently the Chinese government they control TikTok, and they tend to feed Americans. TikTok is a very different thing in China than it is here. Here, it tends towards kind of stupid, dumb laughter humor, which at the end of the day, everyone likes a good laugh here and there, but it just kind of trends towards that sort of stuff and things that are a little more politically questionable. Whereas in China, they limit them, I think, to something like 3 hours a week maximum they can use it. And it trends towards rocket science videos and biology videos and physics videos and stuff like that, which is fascinating.
I mean, I know that there is a serious question about TikTok in our federal government. They won't let it on any federal computer. Anybody at the DOJ can't load it on their phone or their whatever, because of the connection to the Chinese government. And I'm going to tell you right now, my wife, I think she has Facebook, and we have a Facebook link and for our website and so on and so forth. But I personally have never been on Facebook, and I really don't have any interest.
There's probably wisdom in that. I'm
not American.
I'm going to say one thing that's political, and it's not taking a jab at either side of the aisle, because I don't like either side of the aisle very much. But I think it was Schiff. Adam Schiff was on the House Intelligence Committee. He recently got kicked off, and the very first thing he did was make a TikTok video about how he needs to fundraise so he can, I guess, run for Senate or some other position that he's in the House before or whatnot. And I just thought it was really funny that the guy in the Intelligence Committee all of a sudden is downloading and using the TikTok app, which is like the thing that you can't do on the Intelligence Committee.
But yeah, we just talked about that. I wasn't aware of that. That's interesting. Yes.
I'll leave that, again, I'm not trying to get overly political, but I just find humor in it. I poke fun at all sides. I'm the guy that's lost his Facebook account already. I may or may not have a burner account that I still post political memes and whatnot on. But I may or may not have lost my account in the past. Anyway, so to be respectful of your time, here in a minute, I'll ask you the concluding question. And my last questions are always the fun ones. Question number one will be, if we can go back in time and give young Michael Brady some advice, other than buy a lot of Bitcoin, trust me. If I can give yourself some advice when you were first starting out, what would that advice be? And then question number two is, if I give you my magic pen, and I'm not sponsored by Paper Make Joy, I just really like this pen. But this pen is unique because this pen can actually strike laws from the books. It can edit existing laws on the books, or it can add new laws to the books. That's why it comes in 4 colors. What law would you strike, would you edit, or would you add, and why? And this can be a really big law that has sweeping nationwide ramifications, or it can be a tiny little stupid law that forces you to fill out forms in triplicate every time you process a case or whatever it happens to be. So think about that. And while you do that, jump over really quickly, and we're going to read from our last sponsor and take a look at your site again. If you have a whistleblower issue, Brady Associates Law Office, MBradyLaw.com, link in the description down below. You can give them a call, 913-696-0925. Consultations, I believe, are always free. And again, you don't know your rights. If you don't know your rights, you don't have any. So, you don't know what you don't know. If you think you have a whistleblower case, you definitely should be talking to an attorney. And if you're particularly, definitely in the Midwest, but I think we talked earlier, you work with people across the country, if I'm not mistaken. So, start somewhere, but work with an attorney. If you're in the Kansas City, Missouri area, I know for sure that you're barred there. Reach out to Michael, give him a call, go to his website, etc. Our last client.
I'm sorry. No, I didn't know if you were done. I had one other point to add, but finish your other sponsorship issue if you need to.
Well, the other sponsorship is my own, so I don't mind cutting into that one as much. But everyone knows I run a marketing company called Hundreds of Customers, and our flagship product is Rank with News. And so our last sponsor is my own, Rank with News. If there is a guaranteed way to get your firm or your business featured in major news publications like Yahoo News, Forbes, Bloomberg, and others, and to see those articles ranked locally, sometimes in under 8 hours for major competitive keywords that people were looking for, what else would you need to know? Rank with News is simply the most powerful way to hit page one in under 2 weeks safely, organically, and usually permanently. This is guaranteed SEO, search engine optimization, basically on steroids, and it's ranking quickly and sticking. Visit rankwith.news to learn more and book a time to speak with yours truly or a specialist that I have on standby about featuring your firm or your business in major national 8-figure traffic sites that can launch you to page one in a matter of hours and help you dominate your local marketplace, get more traffic, get more credibility, and ultimately, of course, get more customers or clients. Visit rankwith.news. And now we'll jump back over to your site. That is MBradyLaw.com. So you were about to make a point based on what I just asked. Go ahead.
So I'll answer your two questions, and it's the age-old story when deposition or otherwise, when a lawyer says they have one more question, there's about 10. But anyway, no, the other thing I was going to say when you're talking about geographic practice area, the FCA arena, let's say it's a practice or something. These things are becoming nationalized in a great deal. So the bottom line is trying to confine this to the Midwest even is probably too narrow. For example, we successfully worked on a case for disadvantaged business fraud. So it's the classic example of a suitcase contractor, paper only, that the general contractor sets up to to meet the disadvantaged business set aside in a federal contract. But the general contractor is really doing all the work, and it's really not a DBE doing disadvantaged business. Disadvantaged enterprise doing the work. So as I say, don't confine it to the Midwest. I've looked at stuff all across the country. What would a young Michael Brady, whatever. I think I probably would have curtailed some of the previous ventures I had sooner and gotten into my law practice because candidly, I've been doing this 23 years and I probably should have been started 10 years earlier. But that's that. And the other thing is, candidly, the biggest single hallmark, and I don't mean to be difficult with anybody that calls me, but the biggest hallmark as a plaintiff's lawyer where you're working on a contingency and you're getting in the boat with the client to try to pursue their matter is you have to be extremely cautious and picky about what you spend your blood and treasure on, your resources, your time, your money, your staff, all of those sorts of things. So, you need to really husband those resources and be very, very careful. As to the question of what law would I change or whatever, as I tell people from time to time, the right to a jury trial is actually enshrined in the federal Constitution. And what has happened over their law became the Federal Arbitration Act came along, and it actually started the history of it. It was about very sophisticated, difficult, large commercial businesses. It actually came out of the maritime arena, where you had ship owners suing other ship owners or ports, or very complicated commercial transactions. And it has gotten boiled down, and it's given us the outgrowth of forced arbitration. And on top of that, in the consumer arena, it's led to you sign a consumer contract. I'll use an example. You want to get a cell phone. If you don't agree to the cell phone contract that the company provides, and I think this is universal, that I've seen, you agree to arbitrate any dispute you have, meaning waive a jury trial. And furthermore, you agree that you will pursue it on an individual basis. You won't do it as a class action. Now, I don't know anybody that's going to spend $50,000 or $100,000 to go litigate something where their damages for their overcharges on their bill were 50 or $100. I mean, It's just absurd. And those are classic examples of where consumer class actions make sense. And they have been literally just judicially and legislatively confined to the dustbin of history. And I think it's atrocious. The other thing is, as I tell people, you're agreeing to waive your right to a jury trial. Now, in a criminal context, you can waive your right to a jury trial, but you've been accused and arraigned, and you know what you're facing before you make that decision. These, under the theory, the ethereal freedom of contract argument, people can decide how they want to deal with their disputes up front. So you've signed away your right to access to the courthouse at the front door before you even know what you're fighting about. And if that's a law that I could change, that would have great effect.
All right. Well, that is an interesting answer, one I've never received before, and I always like to see new and different answers. Well, Michael, I want to thank you very much for taking the time to talk with me today and talk with my listeners. I feel like I've learned a lot in this conversation. Again, it's been a very different conversation than I usually have, and I can tell you've got a wealth of knowledge in this area. I do always like to give my guest the last word. Do you have any parting words of wisdom or advice that you'd like to leave our listeners with?
If you have anything that you think is askew, talk to myself or one of the other practitioners in this area, first and foremost. And I talk to so many people, they think there's something wrong, and so they take it to the management of the company, and they're shocked that the management of the company isn't receptive to it. And then they realize that they've painted a target on their back. It's kind of a difficult call, but I would tend to encourage people to err on talking to somebody like myself about this rather than escalating it and so on and so forth. Because a great many whistleblowers, my own and other members of the Taxpayers Against Fraud organization, universally they say, I went up the chain like I was supposed to, and then I realized after I'd gone through the trap door that it was a one-way door, and then the exercise frequently became to get them out the door.
Gotcha. Okay. Good advice. Well, I want to thank you again very much, Michael, for taking the time to talk with me and my listeners. This has, as always, been The Attorney Post, and I've been chatting with Michael Brady of the eponymous law that bears his name, Brady Law Office, Brady Associates Law Office. MBradyLaw.com is his website. Link and phone number, as always, are down below in the description. As always, this podcast does not constitute legal advice, and if you do have a legal issue, you should always seek the advice of a competent attorney in your area who focuses on the matter that you need help with. Obviously, if you live anywhere in the Midwest, especially, but even nationwide, it sounds like Michael knows what he's talking about, has a wealth of experience, and so I can confidently say I would recommend, giving him a call and at least getting the ball started and figuring out what your rights are. Because again, as I always say, if you don't know your rights, you don't have any. This has been The Attorney Post. If you're listening to this on YouTube, we always appreciate a like, a subscribe, and a share. If you're listening to this on YouTube or on Apple or Stitcher, Spotify, Amazon, whatever it happens to be, a like, subscribe, share, comment, whatever they let you do. Star rating on any of those accounts is always very helpful as well. And until next time, this is Justin.